I enjoyed both the innings. One, as an advocate, you project a particular viewpoint on behalf of your client to the best of your ability. You leave the decision making to the judge. So you're concerned with only projecting one viewpoint. Of course, you want to put in efforts to say that, that viewpoint which you are projecting may be worthy of acceptance by the judge. But final decision making is with the judge. Correct. Whereas when you are acting as a judge, you are purely in the capacity as an adjudicator. So therefore, you are there to adjudicate upon the dispute. Correct. There may be various shades of viewpoints. There may be something which is prevalent, which are the other views which may emerge from the case papers, which as a judge will take everything into account and then find what is the solution which must actually be the appropriate solution for decision making. So therefore, there lies a difference. Of course, both the limbs are working in one direction, that is resolution of dispute. But their roles are slightly different, though their training is identical. According to me, that's a very, very important right. See, if you accept in theory that a person, whether he or she, has a right to excel in life, in the journey towards excellence, there may be certain mistakes committed by the individual. If those mistakes are not forgotten for the sake of, well-being of that person, if those mistakes keep haunting that person, or if the society doesn't let those mistakes be forgotten, then the development of that individual towards excellence will always take a beating. And that is precisely why, after a point, certain things the society must allow him the right to be forgotten. Correct. Depending upon what is the progress of that individual. If that progress is not there, if the individual is working in the same direction, then what we normally see is that the antecedents of a person will certainly be relevant on the future occasions. Correct? Minus such cases, there must be an element that the person's deeds must be forgotten. It depends upon the facts and situation. See, for instance, I gave the example of Lokmanya Bal Gangadhar Tilak. All what he said in the context of what the times were, what he said is Swaraj is my birthright, and as a citizen, I have every right to criticize certain policies of the government. If I criticize certain policies of the government to the extent I am not inciting people to indulge in violence, I am within my rights. Correct? It will not border on what is called the compartment of sedition. So therefore, an honest criticism of certain policies of the government was something he advocated, and that is protected.